Alex, the owner of a boutique hotel, and Lisa, the hotel manager. The issue at hand here is whether Lisa exceeded the authority as Alex agent by signing a contract, catering contract for a price higher than what Alex had approved. Both sides will present their case, and I will make a ruling based on the evidence provided. We will begin with Alex's lawyer.
Thank you, Your Honor. My client Alex has designated Lisa to oversee the daily operation of the hotel. Nevertheless, it is evident that Lisa had beyond the scope of her authorized, however, by entering into a hotel for catering service at a price significantly exceeded the amount that Alex had approved. Lisa conduct constitute a breach of the authority granted upon her, thereby rendering Alex not obligated to adhere to the requirement of this contract. Alex can explain to the court what instruction you gave to Lisa regarding the catering contract.
Your Honor, yes, I told Lisa especially to set up hotel food for hot summer wedding before I left for vacation. For the entire event, I budget around 50,000 ringgit. When I go back, I thought I saw Lisa sign a contract around 50,000 ringgit for more than I approved. To me, this is very shocking.
Thank you, Alex. I would like to refer to the case of Bolton Partner versus Lambert 1889 to support my argument. In Bolton Partner versus Lambert, the issue was whether a principal can be bound by a contract made by an agent without authority at the time the contract was formed. Here are key facts of the case. Fact, an agent without authority made an agreement to sell property on behalf of his principal. Later, the principal ratified agent unauthorized action after the party had attempted to withdraw from the agreement. Issue of the principal ratification after the withdrawal attempts to bind the contract. Judgment. The court had the ratification was effective retroactive. The principal can't bind the other party to the contract as if the agent had authority from the outset. However, the contract was only valid because the principal ratified the agent unauthorized action. In the present matter, as opposed to the situation in Bolton Partner, it is evident that Alex has not provided ratification for this action, as stated in section 149 of the contract Act 1950. When acts done by an agent for his principal. When the principal has no knowledge or does not give authority to do so, the agent. The principal may adapt to ratify or to disown the agent act. If he elect to ratify them, it has the effect as if they had been performed. By his authority, it is imperative that ratification is unmistakable and intentionally done. Consequently, even that Alex has not decided to evident that Lisa surpasses the authority offered upon her by Alex. In accordance with Section 135 of the Contract Act 1950, define an agent and a principal as agent is a person employed to do any act for another or represent another in dealing with that person, while a principal is the person for whom such as is done or is so represented. We state that the agent must operate within the perimeter of their designated authority. In spite of the previous mentioned legal principle, we respectfully request that the court declare the contract void and excuse Alex of any liability resulting from Lisa unauthorized action. Thank you.
Your Honor, it is essential to examine the claims made by Alex regarding Lisa alleged overreach of authority, particularly in light of the principle of apparent authority. Lisa's appointment as the hotel manager granted upon her appearance of authority to act in representative capacity for Alex. From the standpoint of the catering company, it was evident that Lisa possessed the necessary power to engage in the legally binding contract. Lisa, can you explain what happened when you signed the contract?
Can. Indeed, Your Honor, Alex was away. I was running the hotel. I come upon a respectable catering business when the wedding was about to happen. Although I thought they provided excellent service, the cost exceeded with what the Alex had quoted. Knowing the couple getting married wanted something unique, I decided to proceed with the 25,000 contract. I did want to let the West down signs through it would be in the interest of the hotel reputation.
Thank you, Lisa. I would like to refer to the case of Freeman and Lockyer v. Buckers Park of Property, 1964, to support this argument. In the case of Freeman and Lockyer v. Buckers Park Property, the central question was the extent to which a principal may be held accountable for the conduct of an agent who, despite lacking actual authority, possesses apparent authority as perceived by a third party. The following outline the essential particular of the case, which is fact, a property development company, Buckers Park Property, allowed one of its directors to act as its agent in various dealings, despite not formally appointing him with authority. The director entered into contract with third party who believed he had the authority to do so. The company later argued that this contract was invalid as the director had no actual authority. For the issue is, could the company be held liable for the director action based on the appearance of authority? For the judgment is, the court ruled that the company was bound by the contract because the director had apparent authority. The company had allowed the third party to believe that the director was acting on its behalf, and the third party had no reason to doubt the agent's authority. In this instance, it is evident that Lisa possesses an appearance of authority to represent Alex in her capacity as the hotel manager. The catering company, similar to the third party in Freeman and Lockyer, proceeds no ground to question her authority. Consequently, in accordance with Section 150 of Contract Act 1950, definition of express and implied authority, and authority is said to be expressed when it given by words spoken or written. An authority is said to be implied when it is to dealing maybe encounter circumstance of the case which pertain to apparent authority. It is operated under the assumption that Lisa possesses the authority to engage in the contractual agreement, thereby acting in good faith.
I appreciate the effort of both parties in conveying their argument and referring relevant case law. Allow me to provide a brief overview of the information presented today. On one hand, the attorney representing Alex contend that Lisa acts beyond her actual authority, citing Bolton partner B. Lambert to argue that Alex is not obligated by the contract unless he provides ratification. Given that Alex has not ratified Lisa's action, it is essential to note that according to Section 135 of the Contract Act 1950, 155 Contract Act 1950 defines an agent and a principal as agent is a person employed to do any act for another or to represent another in dealing with third person, while a principal is the person for whom such act is done also is represented. Lisa was obligated to operate within the confines of the authority conferred upon her. On the other hand, the attorney representing Lisa contend that she possessed apparent authority due to her role as the hotel manager. The ruling in Freeman and Lockyer v. Berkhurst Park Property support this position, indicating that a principal may be held accountable for the action of an agent when the agent possesses apparent authority. In accordance with Section 140, definition of express and implied authority, an authority is said to be expressed when it is given by word or by word spoken or written. An authority is said to be implied when it is to be inferred from the circumstances of the case, and things spoken or written, or the ordinary course of dealing may be accounted circumstance of the case. It is evident that catering company operate under the assumption of good faith, presuming that Lisa possesses the necessary power to execute the contract. Upon careful examination of the relevant fact and applicable legal precedent, it is necessary to determine whether Alex is obligated to adhere to the term of this contract. Although Lisa exceeds her actual authority, the catering company operates under the reasonable belief that Lisa possesses the apparent authority. Consequently, I conclude that Alex is obligated by the term of the contract based on the principle of apparent authority, while Lisa's actions were not formally authorized. They nonetheless align with the responsibility inherent to her managerial position, and the catering company had no justificable basis to question her authority. So, the court finds in favor of Lisa.